I want you to picture a scenario for a moment. It's the early 1950s. You're a businessman in Manila, and you've just had a really good week, closed a deal, and you're walking around with the proceeds, you're feeling good. Then you get stopped.
Right.
An agent of the law searches you, and they find the money, specifically U.S. dollars and checks.
Which, in most situations, that sounds like a pretty good problem to have.
It usually is. But not here. You're immediately arrested, you're put on trial, and you're told you broke a rule. A rule that says you have to sell that money to the bank within exactly 1 day.
And you'd probably say, what rule? I had no idea.
Exactly. Nobody told me. And the government's response is, well, ignorance of the law is no excuse. You're sentenced to 6 months in prison.
It sounds like an absolute nightmare, but what you're describing is a very real and very important legal battle.
It is. But here's the twist, and this is why we're doing a deep dive on this today. It turns out the government couldn't have told you about the rule. Why? Because they wrote it down, put it in a drawer, and they never actually published it.
You were sentenced for violating a secret.
A secret. And that is the very heart of People versus K-Pole. It's a Philippine Supreme Court case from 1954, GR No. L-6791. And while the setting is from the 50s, the legal principles are, well, they're incredibly relevant today.
For sure. It really gets into what due process means.
It does. So our mission for this deep dive is to tackle one big question. Can a government agency, we're not talking about Congress, but a bureau, send a person to prison for violating a rule that was never published in the official Gazette?
And to figure that out, we have to look at how the court navigated some really tricky arguments about statutes, rules, and what even counts as a law. It gets dense, but the payoff is huge.
Okay, so let's start with the facts. Who was K-Pole and, what was in his pockets that got him into so much trouble?
So K-Pole was the defendant, and he was found with foreign exchange. To be specific, U.S. dollars, some checks, and money orders that added up to about $7,000.
And we should say $7,000 back then was a serious amount of money. This wasn't just pocket change, but I mean, just having foreign currency isn't a crime, is it? What was the actual charge?
The charge was a violation of Central Bank Circular Number 20. This was a regulation that came from a law, Republic Act 265. And this circular was incredibly strict.
How strict?
It said that anyone holding foreign exchange had to sell it to an authorized agent of the central bank within 1 day of getting it.
1 day. That's a 24-hour window.
It's an aggressive timeline. And K-Pole, well, he missed it. He was caught holding the dollars. And the lower court, the Court of First Instance of Manila, they didn't really hesitate. They found him guilty.
And the sentence wasn't just a slap on the wrist?
No, not at all. 6 months in prison, a fine of 1,000 pesos, and if he couldn't pay, he'd serve more time, plus he had to cover all the court costs.
So he's facing real jail time. He appeals to the Supreme Court. And this is where the case gets really interesting. His lawyers don't argue the facts. They don't say, oh, he didn't have the money.
No. They went for the jugular. They attacked the validity of the law itself. Their argument was simple, but it was profound. They said, this circular has no legal force because it was never published in the official Gazette.
In other words, you can't punish me with a rule that was never officially made public. And they cited some laws for this, right? Commonwealth Act 638.
That's right. Commonwealth Act 638 and Act 2930. They argued those laws required publication for any rule with general applicability to be valid.
Okay. But the government's lawyer, the Solicitor General, had a pretty clever counterargument to that.
A very clever, very textual argument. The Soljan basically said, let's read those specific laws very, very carefully.
And what was their point?
Their point was that those acts, CA 638 and 2930, they're basically a list of instructions for the Bureau of Printing. They say what should be published. But, and this was the key to their argument, nowhere in the text does it say that a failure to publish makes the circular void.
So wait, their argument is that publishing is just an administrative task, and if the government messes it up, the law still applies to citizens.
That's it, exactly. They framed it as guidance for government officers, not as a condition for the law to actually work. So if they slip up and don't print it, well, too bad for you, the rule is still the rule.
That seems unbelievably arrogant. I mean, we failed our duty, but you still go to jail?
Yeah.
Did the Supreme Court actually go for that?
Well, this is what makes the case so fascinating. The court actually agreed with the Solicitor General on that specific point.
You're kidding.
No. The court said, you're right, those two specific acts, CA 638 and 2930, they don't explicitly say that non-publication is fatal. So if the defense had only relied on those two laws, Capole might have actually lost.
So the government wins that battle. How on earth did Capole win the war?
The court pivoted. It looked past those specific printing laws to the bigger legal picture. They brought in Section 11 of the Revised Administrative Code and Article 2 of the new Civil Code.
Okay, break those down for us. What do they say?
They established the basic rule for when laws become effective. They say that statutes passed by Congress take effect 15 days after they are published in the official gazette, unless the law itself says otherwise.
But hold on, I have to push back here. Circular number 20 wasn't a statute. It wasn't passed by Congress. It was a rule from the central bank. Why would a rule for statutes apply to a bank circular?
And that is the million-dollar question. The court had to connect those dots. And they did it by looking at the nature of the circular itself.
What about its nature?
The penalty. The court said, look, this circular isn't just some internal guideline about office procedures. It was created to enforce a law, and more importantly, if you violate it, you go to prison.
Ah. So because it has teeth, it has to be treated like a law.
Precisely. The court decided that any regulation with a penal provision has the force and effect of law. And because of that, all the normal safeguards have to apply. The public has to be officially informed before they can be punished.
That just makes so much sense. You can't be punished for a rule you had no way of knowing about. But the court didn't stop there, did they? They dug even deeper into legal history.
They did. They brought up the old Spanish Civil Code of 1889 and the commentaries of a famous scholar named Manresa.
Why go all the way back to a Spanish law from the 1800s for a case in 1954?
Because the Philippine legal system is built on that civil law tradition. And Manresa had already tackled the question of what the word laws even means. He argued that the term doesn't just mean statutes. It also includes regulations, decrees, and circulars.
So the precedent for this was there all along.
For decades, Manresa's logic was beautiful. If a government rule says it takes effect upon publication, that must mean publication is necessary for it to be valid. Otherwise, why even say it?
It prevents the government from having secret laws in its back pocket.
Exactly. The court was showing this wasn't some new idea they just came up with. It's a foundational principle of law. A law has to be made public to be real.
Okay, let's look at the timeline here. Because when you lay out the dates, the whole thing just becomes, well, glaring.
The timeline is the smoking gun.
So, circular number 20. When was it issued?
It was issued in 1949.
And when was Capole convicted in the lower court?
Well, the records say the circular was published about 3 months after his conviction, so we can put his conviction around August of 1951.
And the actual publication date of the circular?
November 1951.
Let's just sit with that. He was tried and convicted in August for breaking a rule that wasn't officially published until November of the same year. He was punished for a crime that legally did not exist when he committed the act.
That's the bottom line. The court was crystal clear on this. The circular bound no one until its publication. At the moment he was holding those dollars, there was no valid legal obligation for him to sell them.
It seems like an open and shut case for acquittal at that point. But there was one last procedural curveball, right? The government had one more trick up its sleeve.
They did, and it's a point that, honestly, in most other cases probably would have worked.
What was it?
The Solicitor General pointed out that Capole's lawyers never brought up the non-publication argument during the original trial. They raised it for the very first time on appeal to the Supreme Court.
And under the rules of court, that's a big no-no, isn't it? You can't just bring up new arguments on appeal. You have to argue the case based on what was presented at trial.
Exactly. It's meant to ensure fairness. The appellate court is there to review the lower court's decision, not to hear a completely new defense. So technically, the Supreme Court could have said, too late, you waive that argument, conviction stands.
But they didn't. Why not?
Because of the kind of error it was. The court said that the question of non-publication isn't just a technicality. It goes to the very jurisdiction of the court itself.
Okay, that's a bit complex. How does publication connect to jurisdiction?
Let's follow the logic. If the circular wasn't published, it wasn't a law. If it wasn't a law, then no crime was actually committed. And if no crime exists, then the trial court had absolutely no power, no jurisdiction to hear the case or punish anyone.
A court has no power to punish someone for a non-existent crime.
Correct. It's not a procedural slip-up, it's a fundamental void. The court decided that a question this vital, one that questions the very existence of the offense, can be raised at any time.
Even if the lawyer missed it the first time around.
Even then. The court essentially said that your right to liberty is more important than a rigid procedural rule in this kind of situation.
That's a huge relief. It puts the burden squarely on the state to prove a law even exists before it can be enforced. So the final verdict.
The Supreme Court reversed the lower court's decision. Capollet was acquitted.
And the costs.
Costi officio.
Yeah.
The government had to absorb them. He walked away completely free.
It's a great outcome for him. But it really forces you to think about the bigger picture. This was 1954. The number of government agencies issuing rules has just exploded since then.
Oh, massively. And that's why this case is still so important today. You have agencies for the environment, transportation, health, all of them issuing binding regulations.
And a lot of those regulations come with serious penalties, fines, losing a license, sometimes even jail.
That's right. And People versus Capollet is like a permanent warning sign for all of them. It says you can't just operate in a bubble. You can't just write a rule and pin it to an office bulletin board and expect the public to be bound by it.
It makes it clear that for the rule of law to mean anything, the law has to be visible.
It has to be. It connects the power of the state to the duty of the citizen. I can't have a duty to obey a law if you haven't fulfilled your duty to inform me of it. It's the ultimate protection against secret decrees.
It reminds me of that story about the Roman Emperor Caligula, who supposedly wrote his laws in tiny print and hung them up high so nobody could read them, just to trap people.
It's the classic example of tyranny by ambush. And while I doubt the central bank was trying to be tyrannical, they were probably just scrambling to manage the economy, the end result for the individual is the same. An invisible law leads to unjust enforcement.
But there's one last thought here that's a bit unsettling. Capollet got off because his lawyers, eventually figured this out.
And that's the really troubling part of this whole deep dive.
The circular was issued in 1949. It wasn't published until late 1951. That's a 2-year gap. You have to wonder, how many other people were stopped, fined, or maybe even imprisoned under that circular during that time?
It's almost certain that many were. And if they couldn't afford a good lawyer, or if their lawyer didn't catch this specific error, they served time for violating a law that wasn't actually a law.
That is a chilling thought. A kind of zombie law that's not legally alive but can still harm people.
It is. And it leaves us with a question for today. How many regulations are out there right now that maybe skipped a procedural step? We assume that the government has done its homework, that every rule we're told to follow is valid.
But People versus Capollet shows that maybe we shouldn't always assume.
Vigilance is the price of liberty, as they say. And in the modern administrative state, sometimes that vigilance means checking the publication dates in the official gazette.
Or at least hiring a lawyer who knows to check.
That too.
This has been a really fascinating look at how something that sounds like a dry technicality, printing a rule in a government journal, is actually a critical line of defense for our basic rights.
It really is the difference between a government of laws and a government of whims.
Well, on that note, we'll wrap up this deep dive. Thanks for listening, stay curious, and maybe keep an eye on the fine print.
See you next time.